Imagine you graduate from El Camino College with your paralegal certificate approved by the American Bar Association, get your dream job, and then buy your dream house. You're living the dream. But then one day your dream becomes a nightmare when you receive a letter from the city that says that the city wants to take your home for public use. Can this hypothetical happen? Yes, it can, under eminent domain. The topic of this research presentation brought to you by Marlene Vasquez and Richard Kim. We will present to you the origins and history of eminent domain, the most famous U.S. Supreme Court case on eminent domain, Kelo versus City of New London, and how it's played out in the state of California. First, the definition of eminent domain. Eminent domain is the power of the government to take private property for public use. Early in the history of the United States, the U.S. Supreme Court acknowledged the power of eminent domain as the authority of the federal government to appropriate property for public uses. The U.S. Supreme Court also said eminent domain requires no constitutional recognition. It is an attribute of sovereignty. Eminent domain is an intrinsic sovereign power of the United States federal government. The Fifth Amendment restricts the power of eminent domain. Nor shall private property be taken for public use without just compensation. So, if the government takes private property, it must provide just compensation, and there must be a public use. What's just compensation? Just compensation is the fair market value of the taking and may include business losses and relocation costs. What's public use? There's various public uses: taking land for parks, infrastructure, highways, railroads, military bases, aqueducts, public buildings, utilities, and schools, all for the public good. What about economic development? Is economic development a public use? That is the question addressed by the U.S. Supreme Court in Kelo versus City of New London.
So I will be discussing a very well-known case, Kelo versus New London, as an example of eminent domain. Some history of this New London, Connecticut area and the homes in Fort Trumbull is that there were families such as the Dairy family that had lived in Fort Trumbull since 1895. In 1996, the federal government closed the Naval Undersea Warfare Center, which had been located in Fort Trumbull and had employed over 1,500 people. In 1997, Suzette Kelo purchased and restored her Little Pink House. In 1998, the city's unemployment rate was nearly double that of the state, and its population of just under 24,000 residents was at its lowest since 1920. In January 1998, the state authorized a $5.35 million bond issued to support the NLDC's planning activities and a $10 million bond issued toward the creation of a Fort Trumbull State Park. Pfizer Inc. then announced that it would build a $300 million research facility on a site immediately adjacent to Fort Trumbull. Local planners hoped that Pfizer would draw in business to the area, and the city handed over its power of eminent domain to the New London Development Corporation, which is the NLDC. The development plans were 7 parcels. So parcel 1 was designated for a waterfront conference hotel at the center of a small urban village that would include restaurants and shopping. The parcel would also have marinas for both recreational and commercial uses. A pedestrian riverwalk will originate here and continue down the coast, connecting the waterfront areas of the development. Parcel 2 will be the site of approximately 80 new residences. This parcel also includes space reserved for a new U.S. Coast Guard museum. Parcel 3 will contain at least 90,000 square feet of research and development office space. Parcel 4A is a 2.4 acre site that will be used either to support the adjacent state park by providing parking or retail services, or to support the nearby marina. Parcel 4B will include a renovated marina as well as the final stretch of the Riverwalk. Parcels 5, 6, and 7 will provide land for office and retail space, parking, and water-dependent commercial uses. So the 9 petitioners, which were the plaintiffs, own 15 properties in Fort Trumbull, 4 in Parcel 3 of the development plan, and 11 in Parcel 4A. 10 of the properties were occupied by the owners or a family member, and the other 5 were held as investment properties. There is no allegation that any of these properties are in poor condition. Rather, they were just condemned only because they happen to be located in the development area. So the case, the city's development agent purchased property from willing sellers and proposed to use the power of eminent domain to acquire the remainder of the land. The question presented is whether the city's proposed disposition of this property qualifies as public use within the meaning of the takings clause of the Fifth Amendment to the Constitution, which is, nor shall provide property be taken for public use without just compensation. Suzette Kilo and 9 other property owners sued the city in state court, challenging the use of eminent domain for the project because the property was being taken for sale to private entities. The trial court partially granted the plaintiff's request for injunction, where the city had plans to put office space were not the right use of eminent domains, but the takings held valid for the parcels where a park and marina would be built. The Court of Appeals affirmed in part and reversed in part, finding all of the takings were valid. The plaintiffs then appealed to the United States Supreme Court. The divided court, writing for the majority, Justice Stevens held that the city's exercise of eminent domain was proper because it furthered public purpose by providing new jobs and tax revenue, while takings conferring solely private benefits for private parties are unconstitutional. The court had long ago rejected narrow view of public use. They looked at the Berman versus Parker case, and Hawaiian Housing Authority upheld taking of private property for transfer to other private parties to remedy blight and avoid the dangers of land oligopoly. The court had held that the state's determination about the benefits of the proposed redevelopment program are entitled to great differences. Courts should not scrutinize each parcel, but should consider the redevelopment program as a whole. In the majority's view, potential economic benefits conferred on the public, even if not reasonably certain, were sufficient to satisfy the Fifth Amendment. The court held that the economic development was a public use under the Fifth Amendment to the U.S. Constitution. So after the ruling, in 2009, Pfizer announced it was closing its research facility next to Fort Trumbull and leaving New London just as its tax abatements were going to expire. It turns out actually that Fort Trumbull and New London has failed after spending more than $80 million of taxpayers' money. There has been no new construction, and the area that was once a neighborhood is now a barren field. The lot is not providing jobs, but rather housing feral cats. And this photo was taken in 2018, about 20 years later, and nothing has been made of the land. Less than a week after the Kilo case came down, the Institute for Justice, who represented the Kilo plaintiffs, launched the Hands of Our Homes campaign with the intention to bring reforms in legislators, courts, and communities across the nation for private property who is being threatened by eminent domain abuse. In 2010, 4 state Supreme Courts had rejected the Kilo case, and other 4 had recognized better protections for property owners. 43 states have responded to Kilo with legal change, including both legislation and amendments to the state constitutions. At least 35 prohibit the kind of takings used in Kilo. Cities can't label ordinary areas as blighted and use that as an excuse to take someone's property and give it to another private party. In addition, grassroots activists emboldened by the Kilo backlash have successfully fought back against projects that abused eminent domain, and 44 projects have been defeated. Suzette Kilo still has her pink cottage-styled home. It's just up a couple miles away from Fort Trumbull in New London. Of course, it's different from her original home, but it really has become a symbol of how much the people fought for their homes together. There is actually a film called Little Pink House in 2018, starring Catherine Keener, that you can actually watch on Tubi TV and Amazon Prime.
In Kilo, the U.S. Supreme Court stated, "We emphasize that nothing in our opinion precludes any state from placing further restrictions on its exercise of the takings power. States may limit eminent domain. And that's what our state, California, did. In 2008, the voters of California passed Proposition 99, which prohibits state and local governments from abusing eminent domain powers to take owner-occupied homes and then giving it to private developers. The California courts have agreed with the spirit of Proposition 99. The California Court of Appeal stated that redevelopment power never can be used just because the public agency considers that it can make a better use or planning of an area. The Supreme Court of California stated, one's land cannot be seized by the government and sold merely in order that the purchaser may build upon it a better house or a house which better meets the government's idea of what is appropriate or well designed. A California case, Cottonwood Church versus City of Cypress, demonstrates the implementation of eminent domain in the state of California. In this case, the City of Cypress, the City Council, voted unanimously 4-0 to take land from the church, Cottonwood Church, to take the church's land and then sell it to Costco. The church owned the land, the city voted and wanted to take the church's land and then sell it to Costco. Think about it. The church, of course, took it to court, and the court ordered an injunction. And the court stated in his opinion that the City of Cypress violated the Fifth Amendment public use utilization. Furthermore, the court stated that the City Council violated the Religious Land Use and Institutionalized Persons Act. This is a federal law that prohibits discrimination against churches in zoning laws. So unlike Kelo, in California, in the Cottonwood Church case, the people won. So what we've seen in our survey of eminent domain is that it is an intrinsic sovereign power of the U.S. government that's limited by the Fifth Amendment, that requires that the taking of private property be for public use and given just compensation. We've seen that public use includes economic development, which was the issue in Kelo versus New London. And we've seen that states, specifically our state, California, can take action and have taken actions to limit eminent domain powers. All this shows the organic, dynamic, and adaptable nature of our legal system.